Hello and welcome to the Minimum Competence episode for Tuesday, April 29th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover Jenner and Block's fight against a Trump executive order, Trump's new move targeting sanctuary cities and states, and a tax change that could put the Atlanta Braves $19 million in the hole every year. Let's remember, the better part of one's life consists of one's friendships, and read today's legal news. On this day in legal history, April 29th, 1992, the Los Angeles riots erupted following the acquittal of 4 LAPD officers charged with excessive force in the beating of Rodney King, an African-American motorist. The brutal 1991 beating had been captured on video and widely broadcast, leading to public outrage. However, when a largely white jury in suburban Simi Valley found the officers not guilty of assault and use of excessive force, it sparked immediate and widespread unrest. Over 6 days, riots, looting, arson, and violence resulted in more than 60 deaths, thousands of injuries, and nearly $1 billion in property damage. The events prompted a national conversation about police accountability, racial injustice, and the legal standards for the use of force. Legally, the case led to significant developments. The U.S. Department of Justice later brought federal civil rights charges against the officers, resulting in 2 convictions. The riots also accelerated efforts to reform policing practices, sparked lawsuits, and influenced federal legislation concerning police oversight. The King case remains one of the most prominent examples in American legal history where video evidence, jury perception, and civil rights law collided in dramatic fashion. Yesterday, U.S. law firm Jenner and Block asked federal judges to permanently block an executive order issued by President Donald Trump that penalizes the firm for its past employment of Andrew Weissman, a prosecutor involved in the Russia investigation. Trump's order, issued on March 25th, aims to restrict Jenner's access to federal facilities and terminate government contracts held by its clients. Jenner argues the order violates the First Amendment's protection of free speech and the Fifth Amendment's guarantee of due process. The case will be heard by U.S. District Judge John Bates, a Republican appointee in Washington. 3 other firms, Perkins Coie, WilmerHale, and Sussman Godfrey, have also sued to block similar executive orders. So far, judges have temporarily halted major parts of Trump's orders in these cases. The broader context involves Trump's pressure campaign against law firms he views as politically opposed to him. Meanwhile, other major firms have pledged significant pro bono support to White House causes to avoid being targeted. Jenner is also suing the administration over its actions concerning transgender rights and agency funding freezes. President Donald Trump plans to sign an executive order requiring the Attorney General and Secretary of Homeland Security to compile a list within 30 days of cities and states that are not complying with federal immigration laws. The move escalates Trump's ongoing battle against so-called sanctuary jurisdictions, which limit cooperation with federal immigration enforcement. This follows a federal judge's recent decision blocking the administration from withholding funds from these jurisdictions. Trump officials highlighted a sharp drop in illegal border crossings since he took office, though deportations have fallen compared to Biden's administration. ICE detention centers are over capacity, leading the government to prepare facilities like Fort Bliss and to continue using Guantanamo Bay for migrant detention. Separately, controversy arose after a Wisconsin judge was arrested for allegedly helping a defendant avoid immigration authorities, an action defended by the Trump administration. Despite divided public opinion, Trump's immigration policies maintain relatively strong approval ratings compared to his handling of all other issues. And in my column for Bloomberg this week, I argue that if Congress wants professional sports to be more equitable, accountable, and less reliant on taxpayer subsidies, it should rethink a looming tax change that would punish the Atlanta Braves, the only MLB team subject to full public oversight. A new cap on salary deductions for public companies under Section 162M of the tax code is set to take effect in 2027, and while not aimed directly at sports teams, it would hit the Braves with an estimated $19 million annual tax hike. Meanwhile, billionaire-owned private teams would continue enjoying deduction benefits without similar transparency obligations. I explained that public ownership brings clear benefits. The Braves are required to file audited financials, face investor scrutiny on major spending decisions, and have less flexibility to threaten cities with relocation demands. Unlike private ownership groups that can easily pressure municipalities for stadium subsidies, publicly traded teams must answer to broader stakeholder interests. Moreover, public teams can raise capital through stock or bonds instead of leaning on taxpayers. Rather than penalizing the only team operating under these conditions, Congress should create incentives like a targeted entertainment industry carve-out to encourage more public ownership. The goal isn't to give special treatment to the Braves, but to promote a model that favors transparency, accountability, and financial independence from taxpayers. Letting the current tax rules stand would send the wrong message, rewarding secrecy while punishing openness. And that's bad policy not just for baseball, but for public trust. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, character is like a tree and reputation like a shadow. The shadow is what we think of it, the tree is the real thing.